Hey, everybody. My pleasure and honor to be here on Market Watch. So, like Anton said, I'm a lawyer. Don't hold that against me. I've got.
Try not to. Try not to.
I've been practicing law for over 20 years. Have offices in the greater Los Angeles area in a small city about 90 miles north of Los Angeles called Santa Barbara, California. Wonderful place. And then our main office is in the Dallas Fort Worth area. But most of my clients, like Anton said, are hunting for real commercial real estate around the country. So we're in the hot markets, whether it's Tennessee, Georgia, Texas, Arizona, New Mexico, Florida, the Carolinas, all over the place. So anywhere you think that there might be a commercial real estate deal, that's usually where you'll find us, one of the lawyers, hanging out, trying to help our clients actually get from acceptance of their LOI to the closing table. So we're a boutique full service firm with a national footprint that helps clients essentially get from acceptance of their LOI to the closing table.
Absolutely. And for those listening, we've done several deals with you in multiple states. And so you're definitely very helpful there. And having you on a show like this interview is the best way to get free legal advice. So, and his first questions here or there to kind
without a bill, no bills.
Yeah, that's good. Certainly, I can also vouch for Dugan and his firm. Right, we work on the financing side with a lot of different lawyers in the syndication space, whether it's private placements as well as standard transaction side too. And very often it's a little bit of a struggle to get the legal side all lined up with lender legal and to get to the closing table on time. We all know it takes a lot of effort to get things done. Right? There are dozens, if not hundreds of items that need to be covered on the legal side for a commercial real estate transaction, and having a law firm and a lawyer who understands what needs to be done and is on top of things is crucial to get to the closing table on time. So certainly Dugan is one of them, right? So certainly appreciate that.
Yeah, I was chatting with some young operators just the other day where they were telling me, well, I was thinking maybe I don't need a mortgage broker. And I was like, no, you need a mortgage broker. And I was like, well, maybe I could do this without a lawyer. I'm like, no, you need a lawyer. Those are usually two very indispensable kind of team members, that one handles the business items that the lender's going to need. So remember, when we're talking about syndication, we're talking about pooling other people's money in order to get the equity required to get the loan, to get the keys to the apartment building. And so there are a whole host of business items that your mortgage broker will help you on. It's an essential. And then, like Anton said, unfortunately, there are lawyers in this space everywhere. The seller has a lawyer. The buyer has a lawyer. Title and survey have lawyers. The lender has a lawyer. So you're going to see lawyers everywhere. It's an indispensable component.
You actually make me wonder if anyone has ever basically told, lender legal, I'm gonna represent myself on this one. Go ahead and send over the documents.
I've had so in the last 20 years, I've had transactions where we've been hired after the loan application's been signed and the term sheet's gone in, and the lender had the kickoff call. And it was just the borrower principal, and they said, time out. We're not doing this. And the reason simple is that lenders counsel don't want to deal directly with the borrower's principals, because they don't want to have some sort of built-in legal defense in the event that there's a default or something that follows further on down the road. The lenders don't want to have to deal with the defensive. Well, I didn't know. I mean, I'm not sophisticated in this stuff. So that's why, in part, not just for the repackaging of selling of securities on the secondary market, why they ask for borrower legal opinion. There's multiple purposes, and one of which is to backstop that risk and that exposure from the bank's perspective, to make sure that when a borrower goes into a transaction, that they actually are a knowledgeable or sophisticated borrower, or they've had a lawyer who essentially informs them, so that the lender, if they have to foreclose or initiate legal action against the borrower, they can say, hey, they don't have the defense of, I didn't know what I was signing, or I didn't read it, or I just signed it. They'll say you were represented by counsel. And so that's why you're going to see many banks. In fact, I can't think of any, but that would actually go through with it on a large transaction where they're loaning millions of dollars without the borrower actually being represented by a lawyer.
Yeah, there are not many lenders that are willing to do it. And outside of the single family space, right? It's just too complicated. Naturally, just one of the items, how do you do your own background search as a borrower? Right? Just that alone is
I vetted myself. I'm good to go. Right.
Yeah, I've checked. I'm good. Let's go.
So maybe jumping gears a little bit, right? So, kind of maybe walk us through, I think the elephant in the room, right? Kind of how has COVID, with what's been going on, right? Kind of what happened, maybe let's talk about what happened in March. Were you able to get all those deals closed or not? And, what happened to some of them, right? And then from that, really moving on to now, right? What's been, given you kind of where you are now, what are you starting to see? And then more importantly, what's your crystal ball say? I think that's I think most of our listeners are going to want to listen to.
Right. So COVID just came out of nowhere, right? So no concept from the legal structure side. It was very rare when we would have like a force majeure clause. When I say a force majeure clause, that's a clause, that's an express clause in your purchase and sale agreement that says, hey, if something happens, we're pulling the ripcord on the buyer side or the seller side. We're out of here, contract over, earnest money back, and the parties go on their way. So pre-COVID, on the legal side, we weren't dealing with any of that. So in January and then in February, we started to hear this thing about COVID. In fact, I was at Disney World with my kids in February, late February, right before they closed the parks. And none of us even at that point really figured out or even had any concept that it was going to hurt the capital markets as much as it did. And so deals in January and February and even March, we were still closing deals, but they were deals that had already been committed and they were further along in the funnel, in the lender's funnel. So it wasn't like the lenders that currently had positioned their funding and gone either to credit or committee or whatever, and they had approved it. Those deals still happened. They still got funded. But as you know, the capital markets froze up. And not just the bridge space, where predominantly a large segment of my clients around the country were looking for leverage in the bridge space. It was also in the agency space. And it was like one night, somebody shut off the lights and it was like, boom. And so deals that were caught midstream, due diligence, maybe the loan application had already been paid, they were over. And so the only deals that we were seeing really crank through the system at that time were creative deals like assumptions or seller carryback or seller financing. Those sorts of deals were still taken place in March, April, May. But the capital markets didn't start to loosen up and for most of our deals until June, I would say. June and July, and now it's red hot, right? But before, in the agency space, while the bridge space is still choked off. So for several months, there was really very little to no activity. People were changing underwriting criteria like crazy. I mean, it was like a dumpster fire when you started to think about, well, what are the reserve holdbacks that you're going to require 18 months, 12 months? I mean, it was like a moving target for many of my clients that were trying to get leverage to close deals. And so what we saw from the legal side were a couple things. One, people that were astute sellers, seasoned sellers, started to understand that they needed to loosen up, meaning the restrictions on hard earnest money on day one, a lot of those things went away. sellers started to realize that maybe we're going to go back to the era of here's the earnest money, but there's going to be some amount of due diligence or 30 days of financing contingency baked into the process. And sellers were more willing to give to meet occupancy criteria so that we could actually get funding at the agency level. That was not happening pre-COVID because the market was so hot. We were in a significant period of growth in the capital markets, and we were doing deals like nobody's business. And so that changed. And then from the legal perspective, we also started to put in express provisions. And for clients that got caught in the middle of COVID, they're not without recourse. There are what we call equitable doctrines in the law. Equitable means when you don't have a legal statute or a case that's directly on point, you fall back on what we call equitable theories. And there are doctrines of frustration of purpose, impracticability, or impossibility. All of those legal theories are what we call equitable theories that allow judges, juries, arbitrators the ability to do the right thing, right? To do the right thing and not force somebody to lose out, because through no fault of either the buyers or the sellers, COVID popped up. So I'm thankful that at least what many of my clients have reported to me and what I've seen in the markets, that people continue to pay their rent, right? So one of the biggest fears that I think all of us that are in the industry started to think about were that tenants were going to do the most dishonorable thing that they possibly could, right? They were going to basically squat. They were going to sit in their unit, the apartment unit, and they weren't going to pay any rent. Thankfully, we didn't see that. People did the right thing. They acted with integrity in most cases. They were honorable. And so we didn't see the massive fears that some people were stoking in the market to foment, like we're going to see massive amounts of properties go under, not be able to meet their debt service because economic vacancy at the properties would go sky high. We didn't see that. Now I think it did help that several of the lenders, there was an eviction moratorium. There was the Fed kept rates artificially low. All of that helped from my perspective on the legal side, making sure that our clients were able to continue to get through that process, and the stimulus that got passed that was able to be helpful, both for PPP money as well as EIDL money. For some clients that were lucky enough to be able to get that was helpful because that helped kind of bolster up the markets during this interim period. So I don't know what's going to happen with the current election. Not Nostradamus. I don't have a crystal ball, but I think whoever sits in the White House are not going to be in the middle of raising rates. So I think that the Fed's going to allow, to a certain extent, maybe inflation to run wild for a while. But if you're going to see price compaction, which some people are saying is potential for the next quarter or the next couple of quarters, I think in large part that's going to be in the single family residential space and not as much in the multifamily space. So I'm still if you couldn't tell, I'm still very bullish on multifamily acquisitions. I love non-recourse debt. I love multifamily. It's one of the rare asset classes that have helped investors for historically. If you track returns and you track returns according to the market as well, there's nothing like commercial real estate, and there's nothing in particular like commercial real estate that's secured by non-recourse debt to be able to provide those types of historical returns for investors. So we've seen a lot from COVID, but COVID hasn't taken us out, hasn't taken any of our clients out. And I think it's going to be a little bit of a hurdle, but we're going to be fine.
And what COVID did is remind people of Maslow's pyramids of needs, right? People need food, water, and shelter third, right? And the government.
Right. Yeah.
Yeah, but it certainly has driven where occupancy has improved, where rent growth has gone up, and where it came down, right? So when we obviously a lot of your clients and our clients, they're active in the more suburban markets rather than in the main urban markets. But we also have some clients that are active in urban markets. They actually suffer much more, right? Whether it's New York City, San Francisco, Chicago. And while they have a massive drop in rents that they can charge, they have a lot of problems with economic vacancy. We see the opposite when it comes to some of the typical markets that everyone has been talking about, like Texas, like Dallas, Fort Worth, Atlanta, even Nevada, right, where the multifamily market just has been on fire, also from a rent growth perspective. So it's really a tale of two cities in a way, right? So you have one side that is really suffering, and then you have other markets that have been doing really well. So one question I have for you, whether you still see that, because we still have clients coming in with PSAs that they have, I don't know whom they use to draft these PSAs, but they still have, we still see PSAs where they don't have any force majeure in general, nor do they have even a limited force majeure that is very specific COVID-19. They have nothing. Right? So they still have these PSAs that they have no way out if COVID-19 somehow tosses a stick into the wheel for them.
I'll tell you who they use. It's the Google Law Group, right?
It's not good. So the reality is, if you're somebody that's looking to sign a commercial real estate transaction and obligate yourself to buy a piece of property for several million or more $1 million, you're going to want some amount of protection for yourself as the buyer, or even as the seller, you want some sort of protection for yourself. You don't want to be tied up in a transaction for forever. You want to be able to have your property free and clear. If you can't sell it to this particular buyer, you want to be able to sell it to somebody else. So the force majeure clause is not just pro buyer, it's pro parties. So often, remember, force majeure means it's an unexpected event. Really, this is Latin for unexpected event. The reality is, we all know about COVID right now, right? So unless you've been living under a rock for the last several months, you know that COVID exists. So you can't use COVID as a force majeure event. But let's say there was as one of the candidates said, there's a dark winter coming. Let's say there is a dark winter, okay? Like Game of Thrones. If that were to happen, right? And then the reality is, in the capital markets were somehow frozen, either by government fiat or executive order from the White House or something like that, right? Or the mother of all dragons swooped down in Wall Street and snatched up the stock market. Then the reality is, that's a new event. Yes, it's tangentially, or if not causally related to COVID, but that's a new event that would thereby trigger the ability, both on the seller side as well as the buyer side, to potentially pull the ripcord through that force majeure clause and get out of that contract. And you say, why is that helpful for the seller? Well, the practical reality is, let's say the buyer says, I want out, and the seller says, I'm not letting you out, or the seller says, fine, but I'm not going to authorize the release of your earnest money. And then there's a lawsuit that ensues. That's what we call a cloud on the title. A cloud just meaning that there's, when the title company goes to pull the abstract or the historical record of what occurs at the property, they're going to see that there's potentially a lawsuit attached to that particular property, and the seller's not going to be able to sell it to anybody else. So even if you're an unsophisticated or non-seasoned seller, and you think to yourself, you're going to help yourself because by holding a buyer essentially into a property, if there's a lawsuit that is impacting, even tangentially related to a property, a lender who is the biggest investor in all of these transactions, many people forget that the lender is the biggest investor, they're not going to give you their loan proceeds. They are not going to fund that loan. And so the reality is these clauses, whether you call it a force majeure clause or an escape clause or whatever, is helpful for both buyers and sellers. So you do need to even to try to have it. Now, that doesn't mean there's not going to be negotiation in what that clause looks like. What are the triggers for the notice period? Is there a notice period that you have to exercise your rights or you're waiving your rights? All of those things have to be taken into consideration when you're negotiating your purchase and sale agreement. But it's important. It's important for lenders, it's important for sellers, and it's mostly important for buyers.
Yeah, so that's the reason why you need a lawyer to negotiate it, right? Don't attempt to do it yourself.
Well, maybe shifting gears a little bit more, right? Kind of, have you started seeing questions from your clients, right? Because you can have a unique perspective, right? You're not brought in before a deal happens. You're brought in deals that are actually happening, right? You're seeing what's going on. And as kind of, I guess, the benefactor of that, you're probably the first person most clients go to even afterwards, right? With questions about, hey, here's what's going on. And maybe my question is, have you seen clients ask more questions about the CDC moratorium and, things that can be done with that? And maybe, what are your thoughts or positions on that?
Yeah, so I don't think an eviction moratorium is a good thing, in my opinion. I think it reinforces this idea that people are. It serves as a backstop to bad behavior. The reality is not the commercial real estate market. And we're talking about office, retail, hospitality is suffering huge, massive losses, right? Because the reality is we don't all have to work somewhere. We don't all have to go somewhere and work somewhere, but we all have to live somewhere. They don't need it, in my opinion, to backstop, provide protection, if you will, for consumers, or the idea that landlords would immediately wholesale kick people out of their properties. One, there's not massive shifts in people wanting to move during the middle of a pandemic, right? So when we're talking about our tenants, they're not out there on the weekends going to open houses or walking through the mall or looking over saying, hey, I'm going to move from this property to this property. So I think in general, it's not a great thing. Let the market decide whether a property is going to be successful or not. But to the people to owners that have availed themselves on the agency side of forbearance, meaning they have decided that they want to, for a time, push pause on their obligation to pay Uncle Sam back the mortgage. I think it's fair that the trade-off is, hey, you can't kick people out, and you can't be in the process of raising rents. So at some point, and I've talked to a number of clients that didn't have agency debt, that had not gone into loans with any of the federal agencies, or were in states that didn't have kind of this moratorium in place imposed by bridge lenders or whatever. And I've said, be sensitive, communicate clearly to your tenants. And if your tenants need a little bit of grace, extend grace to your tenants. So to the extent that you have tenants that need some assistance, or they need a little bit of help, for the most part, my clients that are in the B and C's place, the value add place, the types of rents that we're talking about, they can tolerate for a certain amount of time to be able to extend grace without evicting people. So I would say it's the costs. If you're the landlord, the operator, and you decide, well, I'm not going to negotiate. I don't need to negotiate. I don't need to extend grace. And there's no moratorium. Let's kick these people out. I think what you're going to find is that may be a bad business decision, because the cost to get somebody back in there to turn that unit, and then downtime, as opposed to taking a partial rent not waiving or whatever, but taking partial rent, the economics in some cases don't bear out. So I would say be intelligent, act with integrity, but also extend grace whenever possible to your tenants. And I think in the long run, you're going to be happier.
Yeah. No, I totally agree. I think as landlords, right? Landlords don't want to kick people out, right?
Right.
They need communication and kind of figure out a path forward that it's a win-win situation. So I totally agree with that one.
Yeah. Yeah. A lot of the chatter, obviously, out there is some of the new SEC rules that may come in one form or another.
Yes.
Right? They have been under discussion now for a while. So can you give us a little bit of a flavor of where we stand with all those?
Yeah. So I'm excited that the SEC for the longest time has not decided to deal with this tension that exists between having to be a registered broker dealer when you're raising money, when you're selling securities, versus people that fill the gaps often for sponsors of the deal. They're often you're forced into making two choices. Either when I'm raising capital, I can raise my own capital, and I'm exempt from having to register as a broker dealer because I am considered either the issuer or an associated person of the issuer, meaning we're selling our own securities. This is my deal. I don't have to go register as a broker dealer for my deal. Well, the challenge is, what if I want to partner with other people, right? Because this is a large project, an acquisition. There might be additional underwriting or due diligence or at-risk capital that's needed, or asset managing, all of that. I know this is a team sport. I can't do this by myself. So I've invited 2 or 3 buddies to come alongside and co-sponsor this with me. Well, the question is, are these people legitimate co-sponsors of the deal, or are they essentially raising capital, meaning they're selling securities and getting paid for it, and it's not their deal, which is not compliant? We're not advising anybody to do that. Well, the SEC started, even though for this tension has existed for 15 years potentially, or even longer, they've started to wake up to the notion that it's a good thing to be able to help people raise capital. It's a good thing. The fuel of the economy for America is small business growth. Private capital is needed oftentimes to fuel small business growth in the United States. And so how do you fuel business growth with private capital if you're only capped at being able to use registered broker dealers on this side, or do it yourself? And so the SEC has come out with, they're asking for right now comments about what they're calling a conditional exemption for finders. Finders would be somebody, a person who is essentially serving as the middleman between the person looking to raise private equity and the end investor, the potential investor, right? So and be able to provide a legal compliant framework to deliver compensation to the person that actually delivered the potential investor who invests in your deal. That has been a long time coming. I hope that it is instituted. And what they're showing, at least the foretaste of what they're showing right now that's out, are essentially 2 tiers. We'll have a tier 1 and a tier 2 finder. Tier 1s is what I call the historical rule. And that is, there are people that would introduce you as an operator to potential investors and nothing more. They don't advocate. They don't present your offering. They don't have anything to do with it. They're exit stage right. Anton, meet Feras. Anton's looking to potentially invest. Feras, you're looking for investors. I'm out. And Feras says, here, Dugan, here's a flat fee for essentially making that introduction. That's the historical rule. Okay. Very hard from a compliance perspective to manage that, because What if Dugan decides to tell Anton, hey, Anton, Feras is awesome. Here's this offering. I've already looked at it. You don't need to read it at all. Just give him your money, right? Feras doesn't know that Dugan's telling Anton that. So yet whatever Dugan is doing is imputed to Feras. So if there's ever an issue, that's going to come potentially under scrutiny. So the reality is that tier one, that historical rule, a lot of people did not take advantage of that, and for understandable reasons, because it was hard to manage, and the exposure, the potential risk associated with that was so great, right? Disgorgement, potential bad boy, being put on a bad boy list, suspended from being able to do any further offerings, rescission, having to give all the money back or even sell the asset, fines associated with that. All of those things, the remedies, the full remedies that the U.S. government has at their disposal, they still had. So tier two, that's tier one, potentially. Tier two, which I am excited about, is this prospect, once we see essentially what the conditions are somebody that would be able to essentially assist in soliciting potential investors for operators, and actually be paid a commission or compensation associated with that. Now, these people would not be a co-sponsor, and not be doing due diligence, and they're not going to be signing on the loan, and they're not going to be a part of what we call in the industry the general partnership or the managers side of it, but they would essentially be,
right?
That's right. They're not going to be allowed. From what we've seen under the potential rules, they wouldn't be allowed to do that. But being able to advocate, or at least present the offering to somebody and do something more than just make that introduction, I think is going to be essentially very helpful for a lot of operators out there. And so that is a legal framework that potentially could solve both the tension that exists in the capital raising side of it. And the SEC has recognized that there's a need. In fact, in some of the comments or the discourse that they came out with, their rationale for as to why they want to make this change, providing capital often helps minorities, women, people without voices, without the ability to access capital in the space. Putting a legal framework while at the same time balancing investor protectionism is a good thing. And I agree, and I applaud the effort at frankly trying to do a legal framework, to build out a legal framework that would be helpful for the industry as a whole.
Yeah, no, I totally agree. I think that'll just help give clarity. It's just kind of an opaque thing, and people have a lot of questions about it because there's just no definition of it, right? So kind of getting clarity, I think, will help people.
Yeah, definitely. And also it will bring the cost down, right? So the alternative is, other than just being part of the GP team, right, that you invite someone in and they do due diligence as a management on top of money raising to be compliant. The alternative is obviously to use a registered broker dealer. It's extremely expensive, right? Particularly, I mean, even for a $5 million raise, right, which seemed to be a pretty check from a real estate syndication perspective. For a registered broker dealer, that's nothing. So a $5 million or even $10 million raise, the fees associated with that are just cost prohibitive, right? So it's not really realistic to do that. So I think that's only opening the opportunity to raise money without having to invite someone into the GP team, and then find a way for them also to be active in your business, right? So it's only a very positive development. Question is, how long is it going to take until they come up with a decision?
Come on, please bring it now. Well, they put out their press release October 6th. So, and they said we're going to have a 30-day comment period. Typically, you're going to see, so we're up almost, this week will be the end theoretically of the comment period. And then we should see something in the next month or so. I would think a solidification, maybe a crystallization of what the various components or criteria is going to be, and then a publication in the public register, which will essentially signify, yay, we're open.
Okay, very good. So,
potential business.
So you don't think it will go back to another round of common period?
It could. I mean, it could. You know, the sad thing is the SEC moves at a very glacial pace.
Right.
Understandably, this is a massive regulatory body. They're vested with amazing, awesome power, and they have, you know, obligations to protect investors in not just this industry, but anything in dealing with securities, which, you know, commercial real estate space is like $75 billion on an annual transaction basis. So it's massive, right? Sure. So it could go back for a second round of comments. I'm hoping not. I think it'll kind of depend on what they're seeing in the place. We've certainly done what, you know, we're a small infinitesimal component of this larger cog of other cogs, but we're advocating as much as we can to the extent that this is a good thing. We agree with you. We applaud being able to provide greater access to capital markets and private equity for small business growth, for sponsors and operators, for minorities, for women, for people that want to get involved in this space. It's not just for the fat cats that have the Rolodexes or the friendly relationships with registered broker dealers. This really should be a space for anyone that wants to get involved in. I think is a good thing. So
you bring up a good point. It actually probably even really, if you look at a big picture, it might be for the benefit of the investors even, right? Because ultimately guys that can raise money is very different than guys that know how to operate, right? And so if you know, unfortunately some guys that know how to raise money will end up operating because they're forced to, right? But if you actually separate those out into 2 different roles, it becomes a lot. You know, you have less risk of a bad operator, of a bad, you know, a person that can raise money becoming a bad operator and essentially not performing for its investors.
Yeah, that's a good point. Yeah. So a related question, a topic that has been also been discussed for a while is definition and changes to accredited and sophisticated investors.
Right.
Obviously, for syndicators, that's a crucial piece too.
Sure.
Do you see any changes there on the near horizon?
They made a change a couple months ago. They implemented a change. They expanded the definition of what we historically have known as accredited investor. So, you know, the most common definitions for most operators in the syndication space are essentially net worth and liquidity. Somebody that earns $200,000 in the last 2 years or $300,000 with their spouse, with the reasonable expectation of making that in this year, boom, you're in, you're an accredited investor. Or somebody whose net worth was something north of $1 million when you back out the primary value of their primary residence, which is the largest asset of most people in the country, and the debt associated with that asset. Those are the 2 ways in which we have historically found most of our accredited investors. Well, the SEC is expanding its definition to go beyond just simply net worth and liquidity. And they've expanded it to anyone that might have, or not might have, but anyone that has a particular securities license. So you might have somebody that's just fresh out of school or whatever and gotten themselves a Security 7 license or some other specialized securities licenses. Now you will be treated as an accredited investor. The challenge, I think, and where they potentially missed the mark, in my opinion, respectfully. No offense for anyone that's listening. Respectfully, with all due respect.
How you talk about this.
Right. Respect is that there are lots of people out there through either experience, expertise, what industry they're in, or their educational degree. These are people that are not only sophisticated investors, but they should be considered accredited investors. I think being able to expand it to include people that had maybe an MBA or, a law degree or an engineering degree or some sort of life experience, maybe they don't make $200,000 a year. Maybe they only make $175,000 a year, but they're single. Well, under the SEC's current definition, they're not an accredited investor, even though they have an advanced degree. Maybe they've chosen to run a non, and they're actually on behalf of the nonprofit. They've been investing in other deals, but personally they can't because they're not an accredited investor. You see what I'm saying? There's lots of, and we all know this, right? From an operator's perspective, if you're syndicating, you're doing a Reg D 506B offering, which allows you up to 35 sophisticated investors, you're forced as an operator to essentially burn one of those 35 sophisticated slots for somebody that clearly is as knowledgeable, in some cases more knowledgeable than people that have money. Money should not be the only litmus test, in my opinion, my humble opinion, respectfully. It should not be the only litmus test for defining who is an accredited investor. So I don't think they went far enough on that. And I'm hopeful that maybe they're trying this out, right? So they left themselves the ability to say, hey, we're going to do this in baby steps, basically. We're going to expand the accredited definition of this, and let's see what happens in the market. Let's see how this plays out. And then I'm hopeful that then they would potentially expand it to add additional, maybe educational components, maybe business for so many years, or expertise in some other industries, expand it beyond just the securities business to other businesses, because you know, and I know that some of the wisest people that we've ever met or that are in our lives now may not have even the educational experience or even the high net worth because of personal choices they've personally made or what they've decided to do, and cutting off their ability to participate meaningfully in many of these offerings is, in my opinion, not necessarily fair. I think it harms access to capital. It runs counterintuitive to what they've just done in connection with proposing a conditional exemption for legal finders. So we want to provide more yet reasonable and fair access to capital and to the capital markets. Well, I think you need to expand further the definition of what an accredited investor is.
Yeah. So since they made that change just recently, how long do you think it will take until they actually reconsider a change to that? Half a year, a year?
Nobody knows. I hope it certainly isn't 15 years.
Yeah.
My hope would be that what we're seeing is kind of a modernization, if you will, right? So we've started to see some significant shifts from the passage of the Jobs Act under the Obama administration in 2013 to expanding the definition of what an accredited investor is, to now proposing a potential conditional exemption on finders. I mean, these for those of you that are not in this industry and are like, well, that doesn't sound like much. That's massive. That's like the Grand Canyon of movement that has existed in the last few years. So in the last basically 6 years, 7 years, we've seen a tectonic shift from what has historically taken place at the SEC level. And so I'm hopeful, and it hasn't mattered whether you're a Democrat or a Republican, which is great, because it's one thing that we should all agree on, that people who invest have greater access and greater opportunity for financial freedom. If you don't invest, if you're not in the marketplace, guess what? There's no opportunity for growth. You'll never know. You got to play in order to find out whether you're going to be successful. So I'm hopeful, is what I'll say. I'm hopeful, cautiously optimistic that we'll see some further changes.
Good. Awesome. Maybe one other topic that we have seen popping up regularly, right, is the use of text structures in syndications. from our side, on the financing side, we have seen it for at least 5 years when that they have been used on a regular basis, but it's only among syndicators. It's still kind of to my surprise, a new structure, and a lot of the syndicators still seem to struggle with it, with that concept. So have you seen some changes in among your clients that you're more comfortable with it?
I have. So, I mean, I do my part to speak whenever asked, to say this is a diversified stream of capital. We're saying, when Anton says a tick structure, what we're really talking about are investors who've sold a piece of commercial real estate, and they need to avail themselves of the Internal Revenue Code section 1031. They want to kick the capital gains can down the road and not pay capital gains on that gain. But in order to do so, they need to redeploy that capital back into the market, and it has to be in the commercial real estate space, like kind with like kind. And so what I've told sponsors and operators, whomever will listen, this is a potential diversified stream of capital that can help you. Remember, they are not your investor. They are not your partner. They are a co-owner, or what we call a tenant in common. That's the tick. The tenant is T, in common, IC, tick. So it's not a bug that gets into your head. You know, I grew up, I had to dig ticks out. It's not one of those. It's not a deer tick, not a bear tick. It's a tenant in common relationship that's important for you as operators and you as investors. Investors that are listening to this right now, don't just think that you have to go back in on another single family fix and flip or something in order to do that. There are many operators out there who would be happy, more than happy, to talk to you. Now, within reason, right? So if they're doing a $5 or $10 million raise and you come alongside and want to say, hey, I want to come alongside and buy a slice of the apartment building from the seller, will you allow me for $5,000? The answer is probably no. But if somewhere between what they're looking for and what you have, you meet their criteria, sponsors and operators should listen. They should allow 1031 parties to participate. And essentially that mechanism by which we are compliant and by which the 1031 party does it is through that tick structure, like Anton said, which is like, it has been around, but the problem, and from my perspective, is many people have either were misinformed, didn't understand it, are still confused by it, don't like it, think it's exorbitantly expensive. That's just, none of that is true. And so you can do it. But again, it's going to require you to have a knowledgeable mortgage broker alongside as your team member. It's going to have a knowledgeable attorney that's working the deal to make sure that they're going to satisfy all the lender's criteria and to essentially herd cats to get to the closing table. But it can be done. And from an operator's perspective, this is a great, what we call raise accelerator or raise shrinking possibility, because now you have another diversified stream of capital potentially to help you close the gap and put your deal to bed. So I think it's a good thing for people to think about.
Yeah. So of the deals where you have helped with the tick structure in the syndication, what would you say was the lowest amount for the tick partner that you have seen that came in?
Yeah, so I've had some operators go as low as 150, 200,000.
Really? Okay.
I have some clients that they have if you don't have 500,000, others, if you don't have 3 million, you don't have 8 million.
I think typically,
so
we tell people probably close to $1 million, just because, I mean, it is more paperwork, right? It's not harder, it's not more expensive, but it's just different. And then now you got to go educate the other investors of what's happening, and people don't like change necessarily. So,
yes, you heard it here, folks. One of the operators, there he is. Call him up.
Yeah, that's right. And obviously you're co-owners, right? So you
That's
want
right.
whoever comes in as a co-owner, you want to make sure that for that additional element of partnership that someone brings in a significant amount, enough of a significant amount of money that it makes sense, right? So that's what we have seen in most instances. It's probably closer at that 1 million mark than the 500 or even 150. I'm surprised that someone was willing to
150. I just
to do that 150. But hey, who knows? Maybe it was a good trial for them. So at least they now know how to structure it. So they're not afraid for a larger deal to do it again.
That's right. That's good.
Yeah. Yeah. Very good. So we don't want to stretch your time. So really,
wait. He's not billing us for this time.
I'm mentally exhausted.
Oh,
you guys
yeah,
have beat me up.
My watch and think.
All right, I got a few more for you, dude.
So really appreciate for you coming on and share your wisdom with us, Dugan. So
no, definitely. Thank you
now,
very much, Dugan.
So how can our listeners reach you?
Hey guys, so thankfully my parents blessed me with a very unique name. So you can Google for me. I'm out there, like Madonna, like Cher. Dugan, D-U-G-A-N, at KelleyClarke.com. That's my email. Hit me up. We're on social media. I've got smarter, wiser people in my firm that handle that stuff, but you can find me through that. I'd be happy to chat with any of your listeners about how we might be able to serve their needs, or just chat about any connections that they want to make. We're always here to chat.
I'll recommend it. So
yeah,
just talking about you this morning actually to another group. So yeah.
All right, great.
Yeah, thanks again, Dugan.
Thanks, guys.
Yeah, bye-bye.